My name is Ashley Jones, and I will be moderating today's brand new CMREI online presentation regarding your asset protection, estate planning strategies, and tax savings. If you have any questions, feel free to utilize the panel on your screen and send in your questions and comments. We will be happy to get you the answers that you need. Today, it is my pleasure to introduce to you Mr. Bob Bloom. Bob is one of the nation's leading asset protection attorneys. During his 29 years as an attorney, Bob has been a trial lawyer and has represented Fortune 500 companies as well as smaller privately held businesses and, of course, real estate investors across this nation. As a speaker, Bob has shared the stage with notable political figures such as President Clinton and President Bush. He's even spoken with Margaret Thatcher, Mikhail Gorbachev, and financial figures such as Donald Trump, Jim Cramer, David Bach, Susie Orman, Robert Kiyosaki, and Cherif Medawar. He is the author of several articles on asset protection and is a contributor to the Asset Protection Handbook. Bob specializes in working with real estate investors, business owners, and entrepreneurs from all walks of life. His one-on-one consultations are tailored to you and what you need to have to set up and protect and make your fortress. On this online presentation, Bob will cover many strategies, so please listen and take notes. Over the course of the call, he wants to develop an investing structure designed to protect you from lawsuits and minimize your taxes. Over the next 60 minutes, Bob is available to answer any questions you may have about your investing structure and how to operate your entities so you can grow your wealth more quickly and securely. Please use the panel on your screen to send in the questions and comments. He will answer as many as possible during this call, and then we'll get to the rest of your questions in the next 24 hours. So let's begin. Put your hands together, and let's welcome Mr. Bob Bloom.
Well, thank you, Ashley. It's good to be with everybody. Our topic is asset protection. We're going to be talking about a lot of important things this evening, so we need to get started, and we're going to use our time very, very well, so I am going to move quickly. So please take careful notes on this webinar. It's a tremendous amount of content. Now, I assume everybody on this call is here because you would like to make more money, but also to protect what money you have made up to now and the money you intend to make in the future. So we call making money offense because you're trying to score, and I know everybody loves offense because that's the fun and exciting part of the game. But a lot of people make a very big mistake and think that's all there is to it. I simply have to make more money and all my problems will be over. And you're all smarter than that because you know that offense is a very important part of the game, but offense is only half the game. The other half of the game is defense. And so for the next little while on this webinar, I will be talking to you about defense. And you will have to have a defense every bit as good as your offense, or you do not win this game. You're just in the game and getting beat. So let's get started because some people may be wondering, well, why do I need a defense? Who's coming after me? And the short answer is just about everybody, because the goal is you want to make more money, but the problem is when you make more money, you have to pay more taxes. And yet, if you have a defense, you can make a whole lot more money and slash your income taxes to the bare legal minimum. You preserve the profits you're working so hard to make, and you put that money back in your pocket. So how do we do that? And the answer is we always follow the rules. Now, Congress makes the rules, and Congress has said that you and I will need to do 3 simple things, and we all pay the bare legal minimum in income taxes. Now, before we go there, I want to mention something important. We've got to talk about the U.S. tax system. And to be quite blunt, our tax laws are a screwed up mess. Our tax laws literally say that we can all pay our taxes 3 different ways. They say we can pay our taxes now, we can pay them later, or we can even pay our taxes never. Now, here's what I mean. If you get a paycheck from a job, you're paying your taxes now. When you use an IRA or a 401k, a 403b, other kind of deferred plan, now we're paying our taxes later. And when you take a tax deduction, you are paying taxes never. So if you'd rather pay taxes never, then the key is you need to take more deductions. Now, obviously, you take legitimate deductions, only the ones you're entitled to. But understand, tax deductions essentially give you tax-free income on the money spent on deductions. So let's talk about this for a minute. If you're having trouble with this concept, did you know that if you own a business, you can buy a vehicle for your business and write off the first $25,000 of the cost of that vehicle? Now, think for a minute. When are you paying taxes on this $25,000 of your income when you write it off? Now, later, or never? And the answer is never, because you're deducting that amount. And think of this. What does that mean in terms of dollars in your pocket? Well, if you pay taxes at, let's say, a 30% tax rate, you're talking about $7,500 you would have had to pay to the IRS in taxes, which you now essentially put back in your pocket. So, folks, the key is this. If we want to pay lower income taxes, Congress has said that the number one tax-saving strategy in America today is to, first of all, own a business. Now, you may say, well, I don't get it. Why is it owning a business? And it's simply because business owners get the vast majority of tax deductions in the tax code, while non-business owners get very few by comparison. So, by all means, we want to own a business. Now, understand, owning a business could be you own a franchise, you have your own service or consulting business. It could also mean you own a rental property. That is a business. So businesses come in all shapes and sizes, but the key is you want to get in the game and own a business, because that is where the deductions are if you want to lower your taxes. Now, just because you have a business gets you in the game, but it doesn't mean you've won the game. You still have to be smart about how you run your business, and there are many, many ways you could run a business in our country today, but only one of these gives you all the tax deductions and goodies in the law, and it's called a C corporation. Now, 3 quick reasons I hope you'll write down as to why you never run a business in any other way than as a corporation. And by the way, I'll clarify what I mean in just a moment. But write these down quickly. Number 1, you do business as a corporation because corporations lower your income taxes by giving you far more tax deductions than any other business structure. Second of all, we do business as a corporation because corporations give you liability protection. You'll be way better off having a corporation protecting you when there's a misunderstanding or disagreement and someone sues your business. Folks, now they're suing the corporation rather than suing you personally. So liability and protection is very important. And then thirdly, you'll have a much lower audit risk doing business as a corporation, because the alternative is to do business as a sole proprietor, and sole proprietors are audited at the highest rates while corporations are audited at the lowest rates. So at the moment, we're talking about the first of these 3 reasons why you only want to do business as a corporation, and that is because corporations lower your income taxes by giving you far more tax deductions than any other business structure. And the reason you want as many deductions as you can get is because deductions are where you and I pay taxes never, and that means you are simply putting far more money back in your pocket. So Congress says, yes, you want to own a business, but in order to get the tax deductions available to a business, you want to run it using the correct legal structure. And for most profitable businesses, that will be as a C corporation. Now, not every business will benefit by being a C corporation. Let me explain briefly. There are S corporations. And S corporations, of course, are known as flow-through entities, which simply means that profits flow through to you, but so do losses. So ideally, if you have a business with a loss, we ideally want to be using an S corporation, because it allows you to take the entire loss and use it to offset other income you may have from salaries or investments. So even though you didn't make a dime in your business, you have at least lower your taxes. And anytime you can lower your taxes, that's great. So in other words, we're going to get the full benefit of the loss with an S corporation. Now, the other form of corporation, of course, is a C corporation, and this is typically used for businesses that are making a profit, because now that we're making a profit, we need to reduce the profit or offset the profit through deductions. And it's the C corporation that provides the most generous and numerous tax deductions available. So the rule of thumb is we use an S corporation when we're starting a business and we have a loss. Then we will move to a C corporation once we become profitable. So the normal business cycle is we start as an S, we end as a C, assuming we can become profitable. All right? Now, one key thing, when we're talking about real estate, we never own real estate in the C corporation. We will manage real estate in the C corporation. All right? So take note of that, please. Never own real estate in a C corporation. Limited liability companies are a very important tool to be able to use. They're badly understood, poorly understood, because many people assume that they can simply set up an LLC by filling out some kind of canned form that they find on the internet, and they don't really understand the ramifications of what they're doing. Let me explain quickly. LLCs are relatively new simply because, compared to many of the other entity structures out there, they're of relatively recent origin. Now, what that simply means is that the law, in some respects, with regard to LLCs, is still developing, whereas corporate law is very, very well settled by comparison. It's been around for many, many years. So LLCs are evolving, and as most legal tools do, and one thing to be aware of is that one particular type of LLC is becoming increasingly disfavored by courts around the country, and it's simply this. It is called a single-member LLC. That means you're the only member of it, the only shareholder, so to speak, or the only owner of the LLC, and if that's the case, many courts are ruling that you have essentially no liability protection. You are essentially a sole proprietor. So many of these LLCs have been formed as single-member LLCs, so ideally we want to change that to a multi-member LLC rather than a single-member LLC. Now, also be aware that LLCs can be taxed in 4 different ways. They can be taxed as an S corporation, a C corporation, a sole proprietorship, or as a partnership. And you may choose any of those methods. Now, there are default methods, which, if you don't know what you're doing, the IRS will automatically classify your LLC as being taxed as one of these. So beware, be careful as to how you structure your LLC, how you choose to have it taxed. I'll be honest with you and quite blunt, if you don't mind. The vast majority of LLCs I have seen that people set up by themselves, that especially when they've gotten some form off of the internet, they have no idea what they're doing. Those LLCs generally do you more harm than good. So if you know what you're doing, if you've gotten some counsel, a little bit of advice about what's the best way to structure this, what's the best way to have it taxed, then you have a good chance of having an LLC that will actually operate and produce the kind of results that you are expecting. All right? Now, Congress has a list of 3 requirements for everyone to satisfy if we're going to pay the legal minimum in income taxes. The first requirement, as you know, is you want to own a business, because that's where the tax deductions are. Second of all, Congress says you want to run it using the correct legal structure, and for a profitable business, that is generally a C corporation. All right? Now, there are many deductions available to C corporations and those who have a business. Not all of these are just exclusive to C corporations, but many deductions. And I want to point out also that you also must have, for many of these deductions, certain key words in your corporation documents. Now, people will ask, what's the difference between an S and a C corporation? And in a nutshell, it's fringe benefits. S corporations provide minimal fringe benefits compared to C corporations, which provide generous fringe benefits, which is the same thing as deductions. One example is medical benefits. And just to illustrate, with an S corporation, the rules are you may write off the cost of your health insurance premiums. Now, in other words, you may deduct the cost of health insurance premiums, which could be, you know, a few $100s or to over $1,000. And that's a nice deduction. But that is what you're limited to, is deducting the premium payment. With a C corporation, the rules say you can write off 100% of your medical expenses. And that may well include health insurance premiums, deductibles, co-payments, prescription drug costs, alternative remedies, vision expenses, dental expenses. The kids need braces. You write it all off. So studies show the average American family, a typical family, you know, 2 parents, 2 kids, spends between $15,000 and $20,000 a year on medical expenses when you add everything up. And someone with a medical condition could be spending much more. Now, the point is simply this. Whatever you and your family may be spending on medical expenses, the question is, how do you get to take all those expenses and turn them into tax deductions? Well, here are essentially Congress's rules. Number 1, Congress says you must own a business. Second of all, you must have the right legal structure, which is a C corporation. And then third, you must have the right keywords in your corporation documents. And as an example, those keywords to write off medical expenses are called a Section 105 medical reimbursement plan. And when you have included those keywords and followed the rules, now you may be entitled to significant medical deductions. The point really that I want to make is the tax code is very, very complex. I strongly encourage you to have good accounting help to help you if you have a business. Accountants can be extremely valuable to point out the deductions you're entitled to, what the rules are for taking those deductions. But the bottom line is you have to have a plan for your money. Because if you don't have a plan for your money, you know who does have a plan for your money. And I don't think you'll like Uncle Sam's plan. All right, now we're going to shift gears for a moment, and we're going to leave the tax area, and we're now going to talk about lawsuits. So let's assume for just a minute that we are trying to understand why we have so many lawsuits in America today, and there are many, many answers to that question. First of all, I'd like you to just ask yourself to kind of put this into context. Ask yourself some questions. And if you have a few years that you can look back on, I'd like you to think about this. If you compare today with 40 years ago, would you say that lawsuits are more common today than they were 40 years ago? Would you say that there are more things you can get sued for today? Are damage awards bigger than ever? And is this trend likely to continue? And if you've answered yes to those questions, as most people do, then I think we have a basis for discussing what comes next. So the question becomes, why are there so many lawsuits in America? And there are many answers to that, but one of the answers must be because of the internet. Folks, has anybody seen this on the internet? Because as soon as the internet became commonplace, lawyers figured out how to use the internet to sue people. As an example, not only this, but here is how to sue a doctor on the internet, how to sue your landlord in small claims court, suing the landlord in 7 steps, and the internet saying sue easy, take the power back. In other words, lawyers looking for business. Well, one other factor is our contingency fee system in America, which basically allows a person who is aggrieved, either they're really injured or they imagine an injury, they go to a lawyer and they say, I want to sue so-and-so, and the lawyer says, well, I'll take your case on a contingency fee basis, which means that as a plaintiff, you pay nothing unless you win. Now, The lawyer is putting up all the money, paying the court costs and charging nothing. So the lawyer will get 30, 40, maybe in some cases 50% of everything they collect. So the lawyer gets paid contingent on winning. Now, you do understand when you're the one sued, the defendant, you will never get a lawyer to take your case on a contingency fee basis. That happens on the plaintiff side. For you, you will be paying hundreds of dollars per hour to defend yourself. So right from the get-go, the deck is stacked against you. Now, one other thing to realize is that because the lawyer has all the money on the line, the lawyer wants to make sure that they're going to get, or they want to have a reasonable expectation of making a return on their investment. And so when they get your name as a potential plaintiff, and they may be thinking of accepting it as on a contingency fee basis, what they will typically do is an asset search. Here's a typical assignment. This kind of site, there are many other sites like this. Listen to what this says. It says this site provides detailed financial information to assist attorneys and clients in determining the economic viability of litigation, which means, in plain English, basically, how much money do you have that we can take from you if we win? Now, it goes on to say, we need to identify your bank accounts, your brokerage accounts, real property, vehicles, watercraft, aircraft, business affiliations, and other valuable assets to satisfy judgment. So if you own it, they're very likely to find it. Now, once they see you have some assets, they really want to know how much. This next site tells them every piece of real estate you own and when you bought it. In addition, lots of other information about you. And once they have your current information, they'll go to a free website called Zillow.com and now find the government appraised value of your home. Now, they don't really care what the government thinks your house is worth, because what they're trying to get at is how much equity do you have in your home, because that is what they can convert into cash in a judgment. So this next site will give them a real property equity assessment, because frankly, this is all public record. Now, it's always been public record, but the difference between today and days in the past is, in the past, they had to go to this office, that office, maybe the next county over, perhaps the next state over. It took too much time and money. They didn't do it. Today, with simply a few clicks of a mouse, they can know more about your finances than you do. Many people, when they finally realize this, feel justifiably vulnerable. And so, and quite frankly, they should feel vulnerable, because literally it's basically discoverable what you own. Now, there are simple and inexpensive things you can do to prevent that from happening. And let me suggest this. If you were able to make it look, at least online, that you didn't own anything, because you very carefully structured your affairs and your assets in a way that nothing would come up under your name, then typically the lawyer is going to be looking at you online and thinking, well, what's 30% of zero? Zero. You know, there's nothing in it for me. Why would I bother to sue if there's no recovery? And they will typically skip right over you and go to the next person on the list. Now, there really are some simple and inexpensive things that you can do to get assets out of your name and to shield yourself online from appearing to have the kind of assets that you have worked so hard for all of your life. All right? So we'll cover that as we proceed. Now, want to talk about the fact that some of you are trying to take comfort in the fact that, you know, I'm a good person, I don't do anything wrong, so why in the world would I get sued? Well, the sad reality is, in America today, you don't have to do anything wrong yourself to get sued. You can be sued for what someone else does wrong. One example of a lawsuit like that is divorce which is in fact a lawsuit. And we have today no-fault divorce. So, you may have a perfectly wonderful spouse, but, if the other side wants out, you're now in a lawsuit. Another example, if you have a business with one person working for you, they injure somebody, you can now be sued for what your employee does wrong. By the way, property owners, you can be sued, of course, for somebody getting hurt on the property. And that is called premises liability. And, of course, you will have premises liability insurance, but the problem there is you never know exactly how much to cover. In other words, if you have $2 million of liability insurance, what happens when they sue you for $4 million? You can never predict exactly what that should be. Another way people are sued, having done nothing wrong or at least lose assets, is because they own assets in joint ownership. There are many forms of joint ownership, but the problem is this. For many of these forms of joint ownership, the rule is if you have a joint owner who does something wrong, you can now lose every asset you own jointly with them, even though you have done nothing wrong. So understand there are much safer ways for two or more people to own an asset together, but it is not in joint ownership anymore. A fifth way people get sued is because they may be doing business with a family member or a friend. You are now in what is called a general partnership if you have not set up a corporation or an LLC. And now in a general partnership, the rule is you have unlimited personal liability for the debts of the business. In other words, you can go broke for what your partner has done wrong. By the way, some people will want to do business all by themselves, and that's perfectly acceptable. But they may think, well, then why would I need a corporation? Because I don't have a partner to worry about. Well, true. But even if you're doing business alone, understand without a corporation, you're doing business as a sole proprietor, which means you have full personal liability. You are the business. There's no separation from you and the business. So when the business gets sued, they're actually suing you personally, and they can now take your personal assets. So we do want to do business even as a one-person corporation. And by all means, that is the correct way to do business. Now, I'd like you to write down one very important reason that we want to do business as a corporation, not only because of the tax savings, but for liability protection purposes. In other words, corporations generally protect your personal assets. So please write that down. Corporations generally protect your personal assets. When they sue the business, now they're suing the corporation, not you, and that allows you to protect your personal assets. Now, those of you who have a corporation or an LLC, that is good, and I want to commend you for doing business the appropriate way as a corporation or LLC. But do understand corporations, LLCs, are not perfect. They must be structured properly. They must be drafted properly. They must have the right keywords, et cetera, et cetera. And also understand that there are loopholes even with properly structured and drafted corporations and LLCs. One of those loopholes is this. Let's assume you have a corporation or LLC. Something goes wrong. They sue the corporation or LLC. And the rule is, while they cannot take your personal assets, they can take the assets in the corporation or LLC. Because corporations do protect personal assets, they do not protect business assets, and the same is true of LLCs. So, big loophole. There are much safer tools that we can use to protect the business assets, but, folks, it is generally not something we want to do, which is to own valuable business assets in operating companies, all right? Second loophole is if you have a corporation, they can pierce the corporate veil, meaning if you have not maintained corporate formalities, you have not kept minutes, you have not used director's resolutions, you have not followed waivers of notice or filed waivers of notice, now the problem is the judge may very well disregard the corporation because you have essentially disregarded the corporation. You have not treated it as a corporation. So why should the plaintiff? And that means they can cut right to the corporation and now take your personal assets. A third big loophole is that as an officer or director of the company, you are personally liable for what the company may do wrong. So they can now sue you personally and take your personal assets, even though you may have a corporation. So there are loopholes in corporations, and to protect ourselves, of course we want to use a corporation, but there's something more. We need to plug the loopholes, and I'll show you a tool that will do that for you in just a little while. So once again, corporations generally protect your personal assets. They do not protect business assets, and there are exceptions to that rule, as we have just seen. All right? Now, so those are the loopholes. Now, one other exception is if you are not actually an officer, but you simply look like an officer because you're functioning as an officer, now you can become a constructive officer. In other words, the judge says, well, you're close enough, you look like it, you smell like it, you're an officer. All right? Now, an eighth way people get sued is because you are the owner of an asset, and that can be very dangerous in and of itself. When your name is on the title, the law assumes you control the asset. In other words, if you let a teenager drive your car and that teenager gets into an accident and your name is on the title, the person who will be sued is typically you, because now you are the negligent party. You allowed a negligent driver to drive your car. So consider. Think hard about what titles you have your name on. Typically, our vehicles, our homes, our bank accounts, our investment accounts, and for all of those assets with our names on the title, understand they can become vulnerable when you, in fact, are sued. So half the strategy is get your name off the titles, and we'll cover in a little bit what name we put back on the title. Now, people look at a list such as we've talked for a minute about, and they'll often say we've got way more liability today than we ever had before, and their first instinct is let's buy more liability insurance. And I certainly understand that. Insurance is important. It's good. I have it. You should have it. It's a good first line of defense, but we always say have a real defense in addition backing you up. And for those who wonder, well, why would I need a backup defense if I have insurance? The short answer is because insurance companies from time to time will deny a claim. And if that happens to you, the question is, how will you survive what could be a multi-million-dollar loss? Well, we could talk about this for many, many more examples, but I hope you've all got the idea. Not one of the people on this list had themselves done anything wrong, but every one of them was sued. And the reason is because of a legal doctrine in our country which is called vicarious liability, which is the legal doctrine that simply says you can be sued for what someone else does wrong. Understand, you can be sued for what your spouse does wrong, what an employee does wrong, what an intruder on your property does wrong, what a joint owner does wrong, what a partner does wrong, what an officer does wrong, what your teenage kid does wrong. We could be sued for what someone else does wrong. And so we don't control these other people's actions, of course. So how do we control our liability today? Because we can be sued for these people's actions. And the short answer is we change the only thing we control, and that is how we own our assets. In other words, do you own your assets in a way that if someone sued you tomorrow, you could basically say, well, sue me all you want, you won't get a thing because it's all protected. And that is exactly the goal that every one of us ought to be able to have. There is a tool that protects you better than any other, and it is called a lawsuit protection entity. And we will be talking about that tool in just a moment. I'd like to point something out because I want to dispel a notion that too many people have, and that is, it surrounds a very important tool that most of us should be using in some form, and that is a tool called a living trust. We should be using this because it avoids probate. And probate is that process when we pass on, which is judicially supervised, under which the court makes sure all bills are paid and that the assets are, the net assets of the estate are distributed to the heirs and beneficiaries. Well, the problem is this. Many people, while they understand the value of the living trust for avoiding probate, they assume too much. They assume it also protects them from lawsuits, and sadly, a living trust does not protect your assets from a lawsuit. Here's why. When a lawyer sets up a living trust, we typically fund it with your assets. We want to put every asset we own into the living trust and thereby avoid probate. For those of you who are listening to this webinar who may have a living trust, you've done a good thing. It is a good tool. My point is simply, you keep your living trust by all means, but you add to it the one tool that does protect. And the tool that protects is not a corporation. The tool that protects is not a living trust. The tool that protects your family from a lawsuit is called a lawsuit protection entity. And so be prepared to take some very, very careful notes on this tool as we proceed, all right? Here we go. I'm going to talk today about one of several tools that could be categorized as a lawsuit protection entity. This is a generic term. Specifically, I'm going to talk today about a family limited partnership, which is pretty much the granddaddy of these lawsuit protection tools. It's the one that's been around the most years. It's roughly 100 years old. The judges are very familiar typically with how well this tool protects you. So to set up a limited partnership, we need both a general partner and a limited partner. General partners are typically mother and dad. Limited partners are typically kids and perhaps even grandkids. Now, understand, to set up a limited partnership, we don't have to have this family structure. We can use you as a general partner. We could also make sure that we could make a corporation be the limited partner, or a living trust could be a partner in the partnership. It could be an LLC as a partner in the partnership. So we can, many different people in different configurations can have a limited partnership. All right, doesn't have to be the traditional wife, 2 kids, and husband. All right. Now, going forward, in order to protect ourselves, we establish the limited partnership by filing with the state, and then we put our assets into the partnership. It's called funding. So let's take a simple asset we all own. Let's put it in here, and let's just see how this works. We all own a savings or checking account, I assume, and so think about this. If you own your savings or checking account in your name and someone sues you, they can take your money. If you own your savings or checking account in joint ownership and they sue your joint owner, they can often take your money. And if we own our life savings even in the living trust and they sue us, they can take our money. So if we don't want someone taking our money, we want to put our savings or checking account in a family limited partnership, and our stocks, our bonds, mutual funds, T-bills, CDs, money market accounts, they are now protected by your limited partnership. So when someone sues you, they get nothing, and you've protected every dime of your life savings. Now, real estate investors. We all understand real estate is a higher liability asset than, say, a savings account, because people can slip and fall on real estate. There are things that occur on real estate that are not going to occur on a savings account. And so it is a higher liability asset. And so I want to point out a very important thing, and that is we never, ever want to have all of our eggs in one basket. We want to make sure that we separate business assets from personal assets, that they're owned in different ways. We want to make sure we separate high liability assets from low liability assets. So let me give you a very important rule, and I hope you'll take it to heart, write it down, and that is never own investment real estate in your name. If you're wondering why that is, just think it through for even a few seconds. The asset titled in your name means you're the legal owner. If you're the legal owner, you're the liable party when something goes wrong on that asset typically, and you don't control what your renters are doing on the property. So if you own investment real estate in your name, you've given yourself zero control and 100% liability, which is a very bad position to be in. So instead, we will want to own that real estate in a lawsuit protection entity. It may be a family limited partnership. It may be a limited liability company, depending upon the various circumstances. But now that means when we have our real estate in a lawsuit protection entity, when you are sued, they cannot take your real estate. When there's a slip and fall in the real estate, they cannot take your personal assets. It protects both ways. Protects the real estate from you and protects you from the liabilities on the real estate. All right? Now, another thing to consider is if we have a corporation, we don't want to have business assets in the corporation because they can't protect business assets, as you remember the loophole. So instead, we want to put business assets into a lawsuit protection entity, a family limited partnership, or perhaps a limited liability company, and now they sue your corporation, they get nothing, and you've protected all of your business assets. All right, now another thing to consider is if you have a corporation, but you have not protected your personal assets, they can be vulnerable when they pierce the corporate veil. So instead of leaving personal assets vulnerable, we can protect them in a family limited partnership, and now even if they pierce the corporate veil, they get nothing, and you have protected your personal assets. Continuing on, if you're an officer of the company, they can sue you personally and take your personal assets, so we want to protect those personal assets in a family limited partnership as well. Now, for those of you who own stocks or bonds or mutual funds, if we have a trading account and it's in our names or in joint ownership, it's much safer in a family limited partnership typically, because now they sue you or your joint owner, they do not get the trading account. Now, we have our assets in our family limited partnership, and a beautiful thing happens. Now, at this point, you and your family are protected from a lawsuit. Now, why do I say that? Well, understand that when a limited partnership is filed, the state will typically put the day, sometimes the hour, and the minute on the limited partnership when it's filed. And when a lawsuit is filed against you, that the court will stamp the very minute on the lawsuit when it's filed. And if it turns out the lawsuit was filed after you filed your limited partnership and funded it, now you and your family are protected, and the person trying to sue you is out of luck. But if you procrastinate and you file your limited partnership after someone sues you, the person out of luck is you, because this will not be effective trying to protect assets after you're sued. This must be done in the clear light of day, when no one is coming after you, when there is no lawsuit, when you have no idea of who in the world would possibly sue you. That is the prime time to get yourself and your family protected. All right? So now let's assume we have our family limited partnership in place. It is funded, and there has been no lawsuit. We are well. We can feel very secure that we're protected. Now, why are we so well protected? Because when you have your assets in a limited partnership and someone sues you as the limited partner, understand that the remedy is a charging order. Now, a charging order gives a winner of a lawsuit called a judgment creditor 3 migraine headaches. Headache number 1 is the right to seize a certain percentage of your assets from your limited partnership. The exact percentage they get to seize every time by law is 0. They cannot seize, attach, or levy upon a single asset in your limited partnership, and that is the law of the land in the strongest states in the country. All right? 0 assets. Now, number 2, they can't get your assets, but the law does say you know, it may not be completely fair that this plaintiff goes away empty-handed, especially if they really had a grievance. So let's let them satisfy their judgment by letting them take the net income of the partnership that you distribute. In other words, they can take distributions that you would have received, and instead they will receive and thereby pay the judgment over time. Now, that's not a great result for you, because now, you know, they're taking your money, basically. And so this is when lawyers go to work and draft around bad outcomes in the law. So I'm going to paraphrase from the limited partnership agreement that we have developed over many, many years. And listen carefully, and then think hard about how much of your assets or your income, rather, that you will ever be forced to give to someone who sues you. It basically says this: the general partner, which is typically you, or better yet, the corporation or LLC, the general partner shall distribute the net income of the partnership to each partner every year, except the general partner does not have to distribute income if the general partner decides not to distribute any income. So in that case, that means that the judgment creditor would get zero income. Think about it. Because why would you distribute income? You would not distribute income, and they would come up empty-handed. So no income to the judgment creditor. Now, think about this. They've gotten none of your assets, none of your income, and essentially, when that's the outcome, there is no incentive to sue. But the best disincentive for suing you comes in number 3. And I'd like you to imagine the scenario. Let's assume that you have been sued, you've lost the lawsuit, and the judgment is for $2 million. That's a very, very bad outcome. You're on the hook for $2 million. But the plaintiff has not been able to get any of the assets in the limited partnership. They're not getting any income through distributions. So they've come up empty-handed so far. But the best deterrent so far is number 3. In the year 1977, the IRS issued one of the most important revenue rulings of all time, and it's known as Revenue Ruling 77-137. This is generally considered to be the tax law of the United States, and the IRS, in so many words, says this: we don't care that the winner of the lawsuit was entitled to get $2 million from you, but couldn't figure out how to get it. In other words, they couldn't get assets, they couldn't get income. We don't care. But even though the winner of the lawsuit got nothing from you, the winner of the lawsuit still may pay income taxes on the $2 million you never gave them. You think about that. What is the point of suing someone when the likely result is they will get no assets, they will get none of your income, and instead of getting income, they will have to pay income taxes on income you never gave them? Folks, if that's not a disincentive to sue you, I don't know what is. Now, remember, they get no assets, they get no income, and they will get a tax bill on income you never gave them in the form of a K-1 from the partnership. Folks, that is a powerful lawsuit protection tool. Now, want to mention something in the limited partnership we have? We have a limited partnership form that is a very well-drafted, carefully designed form, and it allows you to, we've numbered the forms to give you guidance and as to what goes in each line, and so we show you what may go in each line, what's appropriate. And so it becomes very, very simple to do when you have this kind of guidance. And number 1, in other words, says put your name there. What is the day, the month, the year? What is your name, name of your spouse, your state, etc. And you fill in a few lines and you're basically done. All right? What's the name of your county as well? So that is one way to set up a family limited partnership. Well, we all own assets, and we hope to own more. And let me try to start to sum up by saying this. What kind of basis do we have for building assets? In other words, if you build a great structure on a bad foundation, it's going to crumble at some point in the future. So let's take a look at our foundation that we might be thinking about building something upon. If you own assets in your name or joint ownership or even a living trust, sadly you have little to no protection at all. Because if you own everything you have in joint ownership, you've got all of your eggs in one basket, and when someone sues you, they can end up taking it all. If you have everything in your name, someone sues, you could possibly lose it all. And if you have it on a living trust, someone sues and it's gone. So the question is, when someone sues you, how much of your money do you want them to take? And if the answer is 0, then we put it in a family limited partnership, because now when someone sues you, they get no assets, they get no income, and they will get a tax bill on income you never gave them. Folks, the reality is, if this is the best they can hope for suing you, my question is, what is the likelihood they would ever sue you at all? And I'll leave that with you. So for those of you who are wondering, well, how do I protect my assets? Let's do a quick review. We set up a family limited partnership. That's the tool that protects. If we want to eliminate probate, we use a living trust. And if we want to pay lower income taxes, we use the one loaded with deductions, and that is a C corporation. These are your major defensive tools. Now, if we had a legal structure that looked something like this, would this legal structure in your mind protect you from a lawsuit better than just having all of your eggs in one basket? In my mind, certainly. If we had a legal structure that looked something like this, would this legal structure put more money in your pocket by allowing you to pay lower income taxes, lower estate tax, 0 probate expense? And so look at how we are winning this game because we have a real defense. We have the right legal structure. So people say, this is great, it's just what I need, but what do I do next? And so to help all kinds of people take that next step, we've put together what we call the Asset Protection Online course. And let me show you what this primarily consists of. It is a 6 online training courses. We found from a lot of feedback from our students that people don't like to read. They want to just hook into a webinar where it's discussed and given to them in a visual way and in an audible way. And so we have 6 terrific webinars that are going to be coming your way. They're 1 hour each, and they're loaded with information you need to know as an investor. So just as an example, how and why to structure your limited liability companies for real estate, tax strategies and lessons from an ex-IRS auditor, living trusts, how to set them up and why do you use them, what do they do, what do they not do, what is equity stripping, what does that mean, how does that work for asset protection, and what huge advantage do you get with that? What are the major tax law changes coming in 2015? Each month, we're going to present you with a new strategy. And by the way, if you'd like us to present on something, we get enough of those requests, we'll create a webinar just for you. So that is with all the support for the next 6 months included. In other words, that is going to be a number of webinars coming your way, and it'll be support answering your questions online for the next 6 months. Also, we have a couple of bonuses for you, and one of them is autofill software. So for those of you who have a simple one corporation to set up, a simple limited liability company to set up, this may be a good way for you to do it because the software allows you to set up a simple structure. You have 2 big advantages as your business grows. You can create as many corporations or limited liability companies or family limited partnerships as you may need, and you have a limited license to share this with family. So if mom and dad need this or that, you can possibly help them out with this very nice software. So because you can actually use this software yourself, that has a tremendous value, and you can use it over and over again, has a very nice value. we place it at $1,000, which I think is much, much too low because it is very, very valuable tool to have. Also, we're going to provide you with an additional online support for 6 more months. So you get 6 months in the online course, but a second bonus is we're going to extend that to a total of 12 months online support. So we want to be able to answer your questions. We will help you, and we're going to provide that support for an entire year. So that's a $1,500 value because there's not going to be a charge no matter what expert you're talking to, and that is a tremendous value. We encourage you to take advantage of it. All right, so let's review. We have the Asset Protection online course with a value of $797. I think you can see why, because you're going to get 6 terrific 1-hour online training courses where we're going to talk about topics that are absolutely vital to you as an investor, from taxes to lawsuit protection to the various techniques you're going to want to use to protect what you've worked so hard for. So that is the basic online course. Then 2 bonuses as well. We have the autofill software valued at $1,000 because it allows you to create this tool or that tool. Also, you will have an additional 6 months of hotline support for a total of 1 year of hotline support. So those are tremendous things. In other words, we educate you, we provide you with the tools, and we provide you with the support as well. That is a $3,300 value, and I think you can see exactly why it's valued at that level. Now, for those of you who have never had any legal work done, you're not quite sure how to price the value of the education, let me put it this way. If you had an attorney simply do it for you, attorneys, as you know, can charge a lot of money. And so you could easily spend $25,000 to $35,000 to get various tools set up that we will cover in these webinars that you could potentially set up with the software. And so you could easily spend that kind of money, and we've had clients that have certainly spent that kind of money as well. So you have the opportunity to accomplish roughly the same thing at about a $3,300 value. Now, because you've spent your time with us on this webinar, we think that you deserve a reward. And so we are going to make available special webinar pricing that is not $3,300 for this webinar. That is a $797 price for the entire package, the online course and the 2 bonuses as well. That is a webinar special pricing, and I strongly encourage you to take advantage of it. Now, when you have the offense, which Cherif teaches you so well, and the defense, which I have just shown you, you have greater financial security. You have worry-free living, and you've got peace of mind. And you've got to ask yourself, what is that worth to you? One guy summed it all up by simply saying, the most important thing is knowing that my wife and kids are protected forever. And folks, that is asset protection for investors. And I want to encourage you to get your asset protection now. Call the number on the screen, which is 407-608-5448, and order your asset protection online course now, along with the 2 bonuses. So I want to thank you for your participation on the webinar, and we'll be talking. Bye-bye.